Welcome back to Court TV Live. I'm Michael Ayala. The Supreme Court has made another controversial ruling that could strengthen the acceptability of some religious practices in other public school settings. Now, the court ruled 6-3 along ideological lines for a football coach from Washington State who sought to kneel and pray on the field after games. Now, the case forced the justices to debate how to balance the religious and free speech rights of teachers and coaches with the rights of students not to feel pressured into participating in religious practices. Well, the new ruling overrules the 1971 ruling of Lemon versus Kurtzman, laying out how government must keep its distance from religion, really a fundamental precept of democracy. Now, the details of Kennedy versus Bremerton School District are represented in two different ways. Justice Neil Gorsuch, he presented a case where Coach Kennedy offered his prayers quietly while joined by players and members of the public, but one parent said his son participated because he feared he wouldn't get to play as much if he didn't. Now, although Kennedy won his case, it's still unclear on future cases where public school employees coerce their students into religious exercises. All right, still with me in studio, former prosecutor, former CIA officer, and criminal defense attorney Jack Rice. And joining us now as our special guest for this segment, constitutional lawyer Andrew Lieb. Andrew, thank you so much for taking out of time again to be with me. And I want to begin by asking you, as I always do, what does this ruling really mean for us as citizens of America?
It's such an interesting question, Michael, because it depends if you believe the facts that Gorsuch said happened or the facts that Sotomayor said happened. But if you're going to go with the majority standard, which is really that he just prayed silently on 3 occasions without members of his team there, and he didn't coerce them because they weren't there, it makes a very small difference. But as you stated before, they took away the Lemon test, which is when you endorse a religion under the Establishment Clause. And that test used to say, did a reasonable observer think you did that? Which may have been the case. And they replaced it with a historical test, which we don't know what it really means. Really, the issue here, Michael, is there's so much ambiguity in the facts, and I'm perplexed how they would go forward with summary judgment and not have a trial to flesh out the facts.
That's interesting, and obviously because of the ambiguity, it raises the question that I'm going to ask right now. You know, we know the classic example is school prayer in a classroom. So does this mean that a teacher in a public school can silently, and let's assume again the facts that the majority assume, can they silently have a moment of prayer in a classroom now, or does that support that type of thing where, again, it sort of pushes aside this idea that students may feel coerced or even sort of as outliers if they have a different religion?
It's not a black and white answer to that either, even under the majority decision, because they said the reason why Joe Kennedy could do this is the period of time that he did it was a period when he had free time. He wasn't cloaked in his scope of employment. He was able to talk with friends. He could have made reservations. He could have checked his email. So if a teacher in the middle of a math class started praying, that clearly would be not okay. But if the kids were going to check their backpacks, maybe it would be okay at that time. It's the timing, everything under the Gorsuch standard.
Interesting. That's very interesting. So let's say the start or before the start of class, there's always these few minutes before a class starts where, you know, there's these moments. Maybe if a teacher did it then, it wouldn't be a problem. Jack Rice, I want to get you to ring in on this. Interesting sort of dichotomy there, and it certainly raises lots of questions. Your thoughts on this ruling by the court?
Well, I really loved how this was fleshed out in the sense that we don't know what the facts are. We don't know how you're going to apply this. You're always looking at the law side of this, and you're looking at how it applies. What we do know is that the conservative majority we're seeing in the court right now has certainly swung this direction. We're seeing more strength, more power in that, and more authority to do more. So we have seen this again and again. This is sort of the latest, but again, because we don't know exactly what those facts are, does this open up more? I mean, if you looked at this from Sotomayor's perspective, she would say absolutely it has. If you take a look at it from the factual perspective argued by Gorsuch, it seems pretty narrow, pretty thin, but I got a feeling this majority is going to take this, and there will be some states who will take this too and say, okay, here we go. We just got a little bit more
to slip
in,
right?
We're going to use this.
And we're going to use it. Quickly, Andrew, one of the interesting quote from Gorsuch was, and it almost seems to be a straight-up attack on cancel culture. He says the Constitution counsels mutual respect and tolerance, not censorship and suppression. It's an interesting comment. I'd love to get your thoughts on that.
I think it's going with just what he's saying right now, that it's opening a crack to make the two aspects of the First Amendment, whether it be the Establishment Clause, which is what we're talking about, that would restrict the teacher from going forward, or the Free Exercise Clause. And it's opening up a crack, and that's the way I would say this, for future cases to see. If you look back at this Supreme Court term, there's been two other notable decisions, one when they denied cert, and then another one when they allowed that Maine school districting, where we're allowing more and more of the free exercise rubric moving forward. But I want to point out that we don't know what the future is going to hold until the future happens. So that's just guessing into the future.
All right. Well, Andrew Lieb, thank you again for joining me this evening. Truly appreciate it. I always feel smarter after I finish talking to you, and I'm sure our viewers do as well. Thank you so much for that. Appreciate it.
Thank you.
Right now, I do want